Hi, I'm going to give you a quick update today on some legislation hopefully coming into Hong Kong in early or maybe mid 2021 with regards insolvency of Hong Kong companies. With the recent pandemic, I think this is particularly useful. So first of all, we have something called the Companies Corporate Rescue Bill. And actually this idea kind of came into Hong Kong back in the very mid 90s, but it didn't really go somewhere. It got retabled in 2001, but there were lots of differences of opinion. Um, Towards the end of 2020, so in November 2020, it was tabled again, obviously with revisions, and this has moved forwards. It's expected to be presented to LegCo in early 2021. I think depending on other legislation going through, that may be delayed slightly. So mid 2021 is my idea. And other legislation will be implemented with it around things like creditor meetings and organisation of committees, essentially everything needed in order to actually enact the bill itself. So as a reminder that the current insolvency landscape differs in Hong Kong, especially from places such as the States, where there's very limited options. Really, there's only two. So first of all, a non-stat agreement. So coming to agreement with your major creditors and working through them. Or some form of scheme of arrangement under the existing company's ordinance. Again, it's a compromise between the company, shareholders, and its creditors. These are all voluntary. The issue with these is that the creditors can still take legal action to wind up the company. So you can go into all this effort of a scheme, and another creditor could come in and wind up the company, for example. And those balances and amounts for that wind up provision is actually quite small, so it's quite easy for someone to come in and do. All this means is that in practical purposes, we don't tend to see non-statutory workouts and schemes of arrangements entered into Hong Kong because they're actually of little practical benefit and there's no moratorium over what's actually happening. So where this new bill actually helps, well, hopefully it's aimed to facilitate the actual attempts for a company to rescue itself. So first of all, there's a provisional supervisor, which in general is called the PS, appointed. And that appointee is done by the company itself. So that can be done through a resolution of its members or of its directors, or the company's liquidator or provisional liquidator if they've actually already been appointed and the company's started to enter a wind-up situation. Now, if there are major secured creditors, they have to be identified before the appointment, and they have to be informed before the appointment that this is going to happen. And they've got 5 business days in order to eject. The initial period that the PS is appointed for is for 45 days. And with consent of creditors, this can be extended to 6 months, which is, probably a more practical point of time to actually work out some of these. The effect of this appointment is that the company is placed into a moratorium. So there can't be a voluntary wind-up. There can be no court applications to wind up. There's very limited court proceedings allowed against the company. And importantly, there's no enforcement against company property without court consent or without the PS, the provisional supervisor's consent. What's worth remembering is that the provisional supervisor actually gains control of the company. So the board of directors are no longer making all of those decisions. This is similar to when it enters into liquidation. So it's a similar kind of control shift. After their term, they make recommendations to the creditors on what should be done. So the object here is to enter into some kind of binding arrangement as such. Very worth remembering is that this is for Hong Kong only. So if the company has assets in other jurisdictions, those other jurisdictions, you also need to consider what risk there is of assets being taken or proceedings starting, etc. That's it. Sure that this legislation will probably change as it goes through LegCo, but this is the guts of it. So this is, I think, is a very positive movement for Hong Kong corporate law and should help companies who have a real ability to work themselves out of liquidation to come to a scheme of arrangement where that can be done, and so save the company, save jobs, and ultimately actually save the monies owed to all of the creditors as well. Any questions, as always, please get in touch. Thank you very much.